I'm Nathan Hecht, Chief Justice of the Supreme Court of Texas. I've been a member of the court for more than 25 years, since January 1989, and Chief Justice since October of 2013. For a few minutes, I'll discuss the way the court conducts its conference. I'm sitting in the conference room as we are making this tape. The court's work is done in chambers where researching, writing, reading is done. Also in the courtroom where the court hears oral arguments, and in conference. In the courtroom, the oral arguments are public. They are webcast, and we try to make those proceedings as transparent as possible. In this conference room, however, all that happens is very confidential. That is so that the judges may discuss among themselves the cases, ask questions, sometimes express doubts, change positions, go through in all of the detail that is desired, the decisions that are being made by the court. We try to proceed as efficiently as we can in conference, but our ultimate goal is to get every case right. Conference is conducted about once a month, although in June we meet for conference every week so as to get as many opinions ready for issuance before the court takes a summer recess and before the end of the fiscal year in August. Each conference lasts a day or two. An agenda is circulated beforehand, listing the matters to be discussed. Usually there will be 12 or 15, sometimes more, opinions, drafts, dissents, concurrences, perhaps research that has been done on drafts that have been circulated. Also on the agenda will be usually more than 100 petitions, some of them on rehearing, some of them the subject of study memos done by the court's legal staff, some of them here for the first time. It is expected that every justice will be fully prepared for conference, ready to discuss all of the matters on the agenda in detail. We prepare for conference different ways. I prepare electronically. I have my iPad here today, but I usually bring my laptop to conference. It has my notes from my review of opinions, questions I may want to ask the writer. It has notes on the petitions to be discussed. It has study memos and briefs that have been circulated, all of the materials I need. Others prepare different ways. Some bring the paper files to conference. Almost all of us have notes that we have taken on drafts and petitions. But as I say, the expectation is that every judge will be fully prepared to discuss all of the cases that are listed. The discussions at this conference table are intense. They are in depth. They are always civil, more than civil. They are respectful. There is a degree of formality, but a degree of cordiality as well, as you might expect on a collegial court. We refer to one another not by first names, so that the discussion will remain directed toward the issues that have been raised. We sit at the conference table in order of seniority. The senior justice sits on my right. The next senior justice sits on my left, and so on, rotating down the table, just as we sit on the bench. But this is one of the few things that we do in which we do not proceed by order of seniority. Rather, on opinions, the author will speak first, and if there has been a subsequent writer, that author will speak first. When the authors have had an opportunity to set out their writings and to point out aspects of them that they may wish to direct attention to. Then the court goes around the room counterclockwise, so that sometimes the senior justices will speak first, sometimes the junior justices will speak first, but there will be a formal order, but not in order of seniority. The law clerks and the court's legal staff attorneys, are seated around the room. As far as we are aware, this court is one of, it may be the only one in the United States at this level where the legal staff is permitted to watch the conference and also sometimes participate. Judges may have questions of law clerks who have worked on a case, questions about the record, questions about the argument or the research, and the law clerks may be asked to answer those questions as we are sitting here in conference. We start with preliminaries and usually emergency matters, mandamuses, sometimes habeas petitions. The staff attorney who is responsible for presenting that particular case will lay out the state of the case, the issues that are involved, and make a recommendation as to any action to be taken by the court. The court will then discuss those, and when the preliminary emergency items have been completed, the court will move on to cases that have been argued. We refer to those as post-submission discussions. In those cases, the judge who is assigned the responsibility for the preparation of the principal opinion in the case will be asked to speak first and to set out his or her views of the case. And then, as I say, we'll go around the room counterclockwise, each judge stating his or her position on the case. When we have finished the cases that have been orally argued, then we move to cases in which there are drafts of opinions, starting with the oldest case first. As I said, the authors will be asked to speak first, and then we'll go around the room and discuss the case as much as any justice likes. These discussions are fervent. They are directed at the details of the analysis. Every effort is made to probe the reasoning and the explanations in the opinions so that when we're finished, we will have confidence that the opinions truly express the decision of the court. And then after we finish the opinions and any rehearings on the opinions, we'll turn to the petitions that have been listed on the agenda for discussion. Besides the agenda, the court will have received a list of all of the votes on the petitions up until the conference. Justices will have had several weeks in which to review the petitions, vote on them electronically. Those votes are gathered by the staff, and a list is circulated to the court just before conference. It takes one vote to discuss a petition, so any justice who wants a petition discussed may ask that it be listed on the court's agenda. It takes 3 votes to request the parties to submit full briefing on the case, and in those cases the legal staff will be asked to prepare a study memo analyzing the issues raised and making a recommendation for the disposition. Finally, it takes 4 votes to grant to hear argument in petitions for review, and 5 votes to hear argument in mandamus or other special writ cases. And so we simply begin with the oldest pending petition, and I will look at the votes and see who has expressed the most interest in the petition, call on that justice to explain the interest in the case, and then we will discuss the petition until the justices are ready to vote. Most of us bring notes to conference to try to remind ourselves of the petitions. 100 is a lot to discuss. It takes usually several hours to finish the petition list, and then that will conclude the conference. After the conference, usually on Monday or Tuesday, then the rest of the week will be spent preparing orders reflecting the court's decisions in the cases for issuance on Friday. For the most part, the court has conducted conference the same way in the 25 years I've been here, and so far as I know, for decades before that. We are now more reliant on technology to list the cases for conference, to make it possible for us to have access to briefs, study memos, and other materials for conference, and for some of us to bring those to conference on laptop computers. So in that respect, it has changed, but in other respects, it has remained the same. And it is always my hope that while the conference cannot be public, that the legal staff who are present and who witness it throughout the year can be proud of the work that they do for the court and that the court does through its conference.